You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg terminal. Bill, welcome back.
Good day.
So a little bit of a departure from the script for today because we didn't record a video last week because you were in Atlanta giving a keynote speech at the annual NCBJ. That's the annual convention of the National Association of Bankruptcy Judges. Bill, how did it go?
Well, it was all going just fine until the lights went out.
Oh, dear.
And I mean went out. We're in a ballroom here with hundreds of people. About 10 or 15 minutes into the speech, the lights went out. And I don't mean dim, I mean out.
So what'd you do?
Well, I kept on talking because I thought real quick to myself. I said, you know, if I stop talking, everybody may head to the exit, trip over each other, and we could have a big mess or a stampede. So I just kept on talking about some of the year's most important cases.
And what did you tell the audience about the Supreme Court cases that they didn't already know?
Well, that was the first part of my speech, Lee. You're correct. In talking about the two cases going to the Supreme Court this year, what everybody views as the most important is executive benefits versus Arkison, which, as I recall, has just been scheduled for argument. I think it's January the 7th. Everybody thinks that's the most important case because it's a follow-on to Stern versus Marshall. If you'll remember in that case, the Stern case, the Supreme Court held that there are certain kinds of state law claims that can only be decided on a final basis by an Article III federal district judge, not by a bankruptcy judge who is not life tenured. This new case, executive benefits, is to decide a question of whether or not someone can waive the right to a final judgment on these Stern issues before an Article III judge. Now, peculiarly, Lee, it's my view that this case, executive benefits, is not so important as the next case that will be a follow-on, because executive benefits has to do with the situation in which the Stern issues were waived for the first time during appeal, not after the case was over, but during appeal. So whichever way it goes is not going to make a whole lot of practical difference in cases that are pending right now. If they are waivable, well, then heck, it doesn't matter. We're already in that situation. If you cannot waive it, then that's a subject I'll talk about in a minute. It's my view, my guess, I guess is a better way to put it, that the Supreme Court will say that Stern rights cannot be waived. Now, that's not based on any sophisticated analysis of Supreme Court precedent. Rather, it's based on what I saw when I observed the justices argue the first case in Stern versus Marshall 2 or 3 years ago. To a man and a woman, the justices, even those who were in the minority on Stern, were very intent on protecting the prerogatives of the Article III life-tenured federal judges. I think they were of the view that if you give the executive an inch, they're going to take a mile. And so at least the majority do not want those powers to be eroded. And that's the reason I think they're going to follow up by saying you can't waive Article III rights. Now, I am, I don't know if that's the majority or the minority view, but there certainly is important people who believe it is waivable, and notable among them is Eric Brunstad. He is the sometimes law professor at Yale and NYU who actually argued successfully and won the Stern versus Marshall case. He is of the opinion that those rights can be waived, and he equates them to the right to a jury trial, which very much can be waived. As I said, I think the next case down the pike on Stern issues is more important. That's going to be a case where the Stern issues are raised for the first time after the bankruptcy's decision is long gone, dead, final, over years before. Indeed, we already have an opinion by District Judge Jed Rakoff in New York in May of 2012. He held that bankruptcy court decisions that fall within the ambit of Stern are entitled neither to res judicata nor collateral estoppel effect. I think where we are headed, if the courts find there is no waiver, is frankly that bankruptcy court opinions aren't worth much more than the paper they're written on when they fall within the ambit of Stern, and that whatever a bankruptcy judge decides can be relitigated, even among the same parties, in a different case sometimes in the future.
I imagine that would create quite a mess out there, but Could be a boon for bankruptcy lawyers out there, maybe?
Well, it's going to be a boon for anyone who loses in bankruptcy court. That's what it's going to be. I think also, by the way, the effect of all of this is going to kill the U.S. magistrate system as we now know it. The Fifth Circuit Court of Appeals about a year ago pretty much said that, but they were bound by their own precedent and therefore did not set aside the magistrate system. So that's another branch that's going to fall out of a tree in the future.
Yeah.
The other major case, bankruptcy case this year, is called Law versus Siegel, a very interesting equity case. This will say whether or not a bankruptcy judge has the ability to use equity powers to glom onto a bankrupt's exempt property, in other words, property that the bankrupt is supposed to keep despite bankruptcy, to make up for fraudulently transferred property that the trustee cannot recover. I think, Lee, this is a huge case, not so much just for bankruptcy, but about federal courts' equity powers in general. This case is going to pit two doctrines together. One, the plain meaning doctrine, because quite frankly, under the plain meaning of bankruptcy law, there is not an ability to eradicate somebody's exempted property. The question is, do the federal court's equity powers nonetheless survive and, in an exigent circumstance, enable a federal judge to depart from the statute? As I see it, Lee, there is a growing sense that the plain meaning doctrine is eroding Article 3 judges' equity powers, which go back in their genesis before the founding of this country. So is the equity doctrine, is the plain meaning doctrine going to erode equity powers? That is, I think, a huge part of what will come out of the Law versus Siegel case. Also, by the way, depending upon how Law versus Siegel is decided, it very may do away with what we call gift plans in Chapter 11, where creditors' committees sue secured lenders who give money in trust for unsecured creditors, bypassing priority claimants who sometimes are not paid at all. I think if you combine how Law Siegel comes out along with Radlax from this last year, I think you may then have the death of these gift plans in Chapter 11.
Right. Well, big issues here, and like you said, it's not all necessarily about bankruptcy law. This is big stuff in front of the Supreme Court.
That's right.
Bill, from folks in attendance, I understand you ended your speech with a recommendation about how to deal with the myriad of issues on which the circuit courts are currently divided. What exactly do you have up your sleeve there?
Well, here's the deal. Preparation for that speech I gave for the bankruptcy judges in Atlanta forced me to go back and read all of the important decisions from federal courts over the last year. What I was astonished to find was that just in the last year alone, there are 10 issues, 10 cases on which the courts of appeal are split. Now, Lee, I don't mean 10 bankruptcy issues overall, over the last 30 years. I mean 10 circuit splits in the last year. The Supreme Court, as you know, takes at best 1 or 2 bankruptcy cases a year. Further, they really don't have the time or the inclination, or for that matter, frankly, I think the expertise to resolve these circuit splits. What we have as a result oftentimes is that people engage in forum shopping, that is, decide where to file a bankruptcy case depending upon a law on a particular issue as decided in that circuit. It therefore dawned on me, because there's so much forum shopping and there is differing laws in the different circuits in this country, that what we need in the U.S. is a federal court of appeals for bankruptcy. First thing I thought about when it occurred to me that we should have a federal bankruptcy appellate court is that neither the Republicans or the Democrats would like it, because it would give one party or the other the upper hand in selecting maybe a half dozen new federal life-tenured judges, and that is not going to fly. I then thought, well, maybe you don't have to do that. Maybe what you can do is you can go to the existing federal circuit judges and get volunteers to sit on this bankruptcy court of appeals. You could get people like Carolyn King, for instance, on the Fifth Circuit in New Orleans, who is, for my money, the best bankruptcy lawyer on any federal bench anywhere bankruptcy courts included. They could serve for a period of years on a volunteer basis. So you therefore get the federal circuit judges who know the most about bankruptcy and would be in the best position to rule. Over a period, relatively short period of time, the circuit splits would be gone, and people would be free to file wherever they want. And as a result, there would be also probably very few appeals that would go up the next level to the U.S. Supreme Court. And the Supreme Court could take the really blockbuster cases that set huge policy, like Stern versus Marshall. And I really do wish that Congress and the judiciary could give some thought to this, because there is already specialized courts for patents and trademarks and all sorts of technical stuff like that, also federal income tax. And I think we desperately need an Article III appellate court to deal with bankruptcy, because, frankly, the more opinions you read, the more you see the law is all over the place. It really isn't much of an exaggeration to say that you can find any case, even on the appellate level, going either way on whatever issue you want to find.
And Bill, just before we close up here, how was the mood down at the conference in Atlanta? Were people trying to be positive, negative? I mean, we talk all the time about where this business is heading. What are the people like when the lights were on in the room?
Well, I think the attendance was pretty large because people didn't have much else to do.
Right.
So they came to Atlanta. On the other hand, as I said in my speech, I believe that the seeds of their next prosperity have already been sown by the Federal Reserve. To my way of thinking, there are 2 or 3 bubbles that are already growing right under our noses. I'm talking not only about equities, but more so about federal government bonds and corporate bonds, where the prices by traditional standards are ridiculously low. If and when interest rates go up, wow, there are going to be enormous losses. And also, by the way, you can make an argument that there is already another housing boom, especially in the last 6 to 12 months. So if I were a bankruptcy lawyer, I would stay current, know what's going on in the business, because things are going to change eventually.
All right, Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go check out Bill's column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates, of course, on Twitter. I'm Pacchia. Thanks for watching.